Under the Administrative Procedure Act, when a federal administrative agency issues a legislative rule, it must follow notice and comment rulemaking procedures. That is, the agency must publish a notice of proposed rulemaking, give interested parties the opportunity to comment, and hold an informal hearing. These steps aren't necessary when an agency issues a policy statement. In General Electric Company versus Environmental Protection Agency, the D.C. Circuit considered whether a particular agency guidance document was a legislative rule. The Toxic Substances Control Act gives the Environmental Protection Agency the authority to regulate the manufacture and use of chemicals known as PCBs. Pursuant to this authority, the agency issued regulations specifying particular methods for the cleanup and disposal of PCB wastes. The regulations also permitted a party to apply for permission to use a different method for PCB cleanup and disposal. The regulations provided that the agency would approve such an application if the alternative method proposed didn't pose, quote, an unreasonable risk of injury to health or the environment, unquote. Because the regulations didn't explain how to assess whether the risk a particular method posed was unreasonable, the agency also issued a guidance document providing an overview of risk assessment approaches. The guidance document stated that an applicant requesting to use an alternative method of disposal could follow one of two risk assessment methods. The applicant could assess cancer and non-cancer risks separately according to a particular formula, or could apply a specific toxicity factor to account for cancer and non-cancer risks together. The guidance document noted that the agency would accept this default toxicity value without further justification. The agency didn't give the public notice or an opportunity to comment before issuing the guidance document. General Electric petitioned the D.C. Circuit for review of the guidance document, asserting that the document was a legislative rule and therefore couldn't be issued without notice and comment rulemaking procedures. In opposition, the agency argued that the guidance document was just a policy statement.